I do realise that we're having a debate later on this afternoon on the public services card, but I just want to get a preliminary view, as it were, of the government's current thinking on the matter and where we are.
This on the record of the House. The PSC was provided for in legislation in 1998 when it was introduced alongside the PPSN number to replace the previous RSI number and the previous social services card, RSI and SSC. And the clear and stated objective, as articulated in the Oireachtas at that time, was that the public services card was not to be confined to welfare services, as has been reported in the last number of weeks, but to act as an identifier for access to a broad range of public services. Successive governments have reaffirmed this policy both in government decisions and through legislation. The Attorney-General's Office advises that the legislation is clear and provides a strong basis for the existing and the continued use of the PSC across the public service. The PSC provides citizens with the convenience of only having to submit information to verify their data once. As an example, about 70,000 people use the PSC to apply for passports each year. We pay over 600,000 people approximately €150 million each week through our post offices using the PSC as an identifier in their cases. 600,000 free travel journeys are made using the PSC every week, and about 400,000 PSC users use the MyGov.ie ID service to access online services with Revenue, SUSI, the National Driving Licence Services, Welfare and shortly the NCS. The PSC has strong public support, approaching 90% of the adult population who hold a PSC, and research indicates that they overwhelmingly value the card. They're fully aware of and agree to the sharing of the data required to enable its use across the public service. They believe that they have more than enough information about the purpose of the card and understand why, and do not object to their data being retained. In October 2017, the DPC commenced the investigation into the safe PSC process and delivered its final report to our department on the 15th of August 2019. On the 17th of September, the department published the report of the DPC, together with a summary of its own response to the findings of the report and related correspondence between it and the DPC.
Minister, I just noticed the length of it. You'd need about 5 minutes to deliver it all, so I'll have to suggest that the remainder will be included in the official report. Otherwise, we'll run out of time.
Chair, no
Deputy
problem,
Willie O'D.
We'll come back to the question of the 1998 legislation when we're debating this later on today. But I just want to ask the Minister, has she fully read the report of the DPC? Would she not agree with me that it's a very carefully researched, very detailed, very analytical report? And it does seem, on the face of it at least, quite extraordinary that the Attorney-General's Office, who had an awful lot less time and spent an awful lot less time considering it, would be able to come to a diametrically opposed conclusion. Now, does she not think that in these circumstances it would be only right and proper that we should see the legal advice on which the government's position is based, or at a very minimum, if there's some rule that I'm not fully aware of that precludes the government from showing us the legal advice, is it not only fair that we should get a detailed analysis of how the state's law officer came to a diametrically different conclusion? And can I also ask the Minister, is she aware that a number of public bodies, such as the Department of Foreign Affairs, the Road Safety Authority and the Department of Youth and Children, have backed off from demanding that an individual should be compelled to produce a public service card to avail of the services which they are offering? Doesn't that indicate that they don't have as much faith in the Attorney-General's Office as the Minister appears to have?
Minister, has 1 minute.
Thanks, Chair. So first of all, I'd love to be able to tell you that I've had the pleasure of reading the report on a number of occasions, but I'm not sure I would classify it as a pleasure. But yeah, I've read it a number of times. And you're right, it's a very comprehensive document. It runs to some 170 pages plus all of the annex. It's significantly different in some 40 pages and some 4 findings from the draft report that we received a year ago. So I hope that answers the first question. The second question is, I think, as is a long-established practice, as you well know from being a senior minister around the cabinet table when some of these decisions were made, Deputy, the sharing of advice from the Attorney-General in the public realm isn't a practice that has ever been established. The Attorney-General advises Cabinet and has advised me and other senior ministers with regard to this, and has been involved in this process since 2017. And so to suggest that they just got together a couple of weeks ago and kind of come up with some response, I don't think is a true reflection of the amount of work that has gone in to both the submissions over the last number of years and indeed all of the engagements that have happened between the EASP and the DPC over the last 2 years, because this is a comprehensive report off the back of what I do believe is a comprehensive review by the DPC. And as I said on the record before, I have respect for the office and indeed the individual. I do respect the position that they hold. We just have a different opinion on the set of legal circumstances that underpins the legislation.
Minister, Deputy O'Dee's.
Oh, sorry, can I just briefly indulge me, please, Chair? Is that there is absolutely a brief available to you, as you are well aware. You've been invited in on a number of occasions by my Secretary-General, and that brief offering still open.
Whatever about the Attorney-General, the Taoiseach didn't seem to require much time to read it, because he stated that even a cursory glance, more or less, like maybe while he was in the car travelling between functions, a cursory glance at all the different sections and subsections and amendments and miscellaneous provisions, etc., would readily lead one to conclude that the Data Protection Commissioner was completely wrong in their 2 years' research. But can I ask the Minister, what is her position now exactly? I mean, is she going to, accept and follow up on what the Data Commissioner has recommended, has in fact directed? Or is she going to allow a situation to occur where she's going to have to be dragged into court to do that, at further expense to the taxpayer?
Final response from the Minister. You have 1 minute. Chair,
the response is in the written text that I would have read out in the first instance had I been allowed. So do you want me to continue reading?
It's not that you had been allowed.
No, I didn't mean that to you. But
those who are preparing briefs know that it's 2 minutes and not 5 minutes.
I think this is a comprehensive issue, though it doesn't.
You have a minute if you want to take advantage of it.
Okay. So in October 2017, the DPC commenced the investigation into the SAFE2 PSE process and delivered its final report on the 15th of August. And on the 17th of September, the Department published the report along with the summary of our own response to the findings in the report. As I stated earlier on this month, the Minister for Public Expenditure and Reform, Paschal Donohoe, and I informed Cabinet and Government that we were satisfied that the processing of personal data related to the PSE does in fact have a very strong legal basis. The retention of the data is lawful, and that the information provided to users does satisfy the requirements of transparency. And this opinion was arrived at following very careful consideration both of the report and of the strong legal advice of the Attorney-General's Office. The DPC had requested that the Department implement a number of actions on foot of the publication of their statement of Friday the 16th of August within a very short time frame. However, based on our strong legal advice, we believe that it would be inappropriate and potentially actually unlawful to withdraw or modify the use of the PSE or the data process that underpin it as requested by the DPC. So in short, and there is 3 more pages, Deputy, we will continue to act in the lawful manner that we believe that we have been doing so since 1998.
Right, we'll move on to the next question.